Va bene, possiamo allora ricominciare. Buonasera a tutti. Io sono Carmelo Di Marco, sono un notaio italiano e sono immeritatamente il coordinatore scientifico di questo seminario e voglio subito ringraziare tutti gli organizzatori e i nostri amici.
First of all, thank all the organizers, our friends, the notaries in Romania that have invited us, everybody present from Italy, from Spain, in this afternoon session. We will tackle 4 practical cases, helping us understand the consequences of the concepts mentioned this morning. Apart from the audience, we will also have 20 other colleagues and operators from other countries that will have the possibility to intervene, to speak in real time, asking questions, of course, through the chat line. I will ask their questions to the presenters so that they can hear the answers. For each of the 4 practical cases, our colleague Daniele Muritano, that prepared the cases and has actually dealt with these cases, will include a context for the case and a suggested solution. Of course, you have to present your opinion with respect to the case in order to argue maybe that the same solution or the same case can have different interpretations or different solutions depending, as I said, on the interpretation. So before starting with the first case, if I may remind all of you that before you exit, you are kindly asked to submit as well the questionnaire, the feedback questionnaire that you have received the morning. So let's start with the first case that Daniele will present. Thank you. Am pregătit câteva cazuri despre regulamentul 650. 2 dintre cazuri țin de legea aplicabilă, un altul despre alegerea legii și ultimul despre 2 probleme legate. Mai întâi
the formal validity of the will and the revocation of the will. In the morning session, the other speakers showed us that lots of problems come out from the regulation, and this depends, of course, from the differences between the different states and the different laws that every state has. The problem about the residents are very, very interesting and very, very complicated to resolve, as Jacopo this morning addressed. And, for example, because some state use a concept of domicile, but with a different definition from the usual common law ones, and the use of nationality doesn't avoid confusion. And the problem that the EU regulation aims to solve is to make a foreseeability of the law applicable to the succession, aspiring to arrive to a unitarian principle of the law applicable to the succession. The first case is about Mark, and it's a case, as I said before, regarding the law applicable. In the slide, you can see the factual situation. Mark is a British citizen. He has lived in Florence for 3 years, not married, no children. He, and this is important, owns immovables in UK and in Italy, and has a bank account in the UK where his salary is credited. He works as a manager for an English company, performing both at the London headquarters and Italian branch. And this is very, very characterizing this situation, he usually spends the first 4 days of the week in England, and on a Thursday evening he goes back to Italy. So, as you can see, we, in this case, don't have stable connected factors with one country or the other country. We have a person who moves from one country to the other and then come back. So the problem is, in this situation, what happened when Mark dies. Okay, the problem is in which country does Mark have his habitual residence under the regulations 650? Because Mark's work doesn't appear decisive, because he works both in UK and in Italy, and his estate covers both the UK and Italy, because, as in the slide I showed, he owns immovables in the UK and in Italy, and has a bank account in the UK. So how a notary or a judge can determine the habitual residence of the deceased Mark under the regulation 650? Here the problem is that the aim of the regulation is that it in the recital 23 we have the regulation said that in order to determine the habitual residence, the authority dealing with succession should make an overall assessment of the circumstances of the life of the deceased during the years preceding his death and at the time of his death, taking account of all relevant factual elements, in particular the duration and regularity of the deceased's presence in the state concerned, and conditions and reasons for that presence. But this is recital 24, said also that in certain cases, as may be this one, determining the deceased's habitual residence may prove complex. And this is the specific case because the deceased, for professional reasons, had gone to live abroad to work there, sometimes for a long time, but had maintained a close and stable connection because Mark has immovables in England and his bank account is in England. So this is a complex case to determine the habitual residence. My proposal is if in this case citizenship may be decisive to determine the habitual residence of the deceased Mark. And this is because this proposal comes from recital 24. And the last paragraph says that if the deceased was a national of one of those states or had all his main assets in one of those states, his nationality or the location of those assets could be a special factor in the overall assessment of all the factual circumstances. So the proposal is that because Mark is a British citizen, the law applicable should be English law. And this is the first case. The second case is a case regarding, again, the law applicable, and regarding a Romanian citizen, Tatiana. She has worked in Italy for 10 years as a caregiver. She has her residence registered in Italy, so in public documents appears that Tatiana is a resident in Italy. And as well as she has a bank account in Italy where her salary is credited. And she monthly transfers part of her salary to her family in Romania and also to another bank account she owns in Romania. Her children, her mother and her sister all live in Romania. She bought also a house in Romania too. Again, the question is, in which country does Tatiana have her habitual residence? And again, recitals 23 and 24 can help us to determine the habitual residence. In particular, this situation probably is encompassed amongst some of the complex cases described in recital 24, because we have the important connection with Romania. In fact, the recital 24 says that we have to consider Tatiana to have her habitual residence in her state of origin, in which is the center of interests of her family. In fact, her children, her mother, and her sister all live in Romania. And she also bought a house in Romania too. So this may we can have this connecting factor to be decided to determine which is the habitual residence of Tatiana. In this case, the habitual residence may be the Romanian residence, so the Romanian succession law will be applicable to the Tatiana's succession. Of course, this is our proposal, but these two cases shows us that the determination of residence is very hard, and so the position of notaries that have to issue the certificate of succession may be very, very hard, and also because instead of judges that can investigate about all these connection factors, notary do not have these powers of investigate. And so a lot of problem we can have in dealing with these problems. They are very, very particular to decide. Case number 3. Yes.
Scusa se ti interrompo. Prima di passare al terzo caso, mi sembrano pertinenti ai primi due alcune delle domande che sono arrivate tramite il sito del seminario, che rivolgo a te, ma visto l'argomento trattato nelle domande, in realtà chiederei anche agli altri relatori presenti al tavolo di intervenire e di offrire la loro opinione. La prima domanda: ai fini della individuazione della residenza abituale, che rilevanza ha il luogo in cui vivono i parenti più prossimi della persona di cui si tratta? Che è un argomento che abbiamo in qualche maniera toccato con riferimento al caso numero 2 di Tatiana, e meno per quanto riguarda il caso di Mark, che non ha coniuge e figli. Ecco, tu forse hai già anche dato qualche indicazione al riguardo, vorrei coinvolgere su questo anche gli altri.
Yes, I think that according to recital 24 of the regulation, the family interests of the deceased may be relevant, because the wording of 24 of recital 24 said speak about center of interest of his family.
Scusa Daniele, mi dicono che c'è un problema tecnico di audio, adesso lo risolvono per le persone collegate a distanza.
Okay.
Scusate. Ma forse anche per i traduttori simultanei.
Bada Sala vorbește italian.
Io intanto anticipo una domanda che è collegata a questa e che forse va rivolta soprattutto a Lorenzo.
So speaking about the place, the living area of the relatives and their residence. It's quite interesting to assess what is going on if the certificate of succession has other information different from what was registered in the documents. Hopefully the technical solutions will be handled.
The connection factor is come out from recital 24. In fact, as I write it down in the slide, the center of interest of her family is very important. But the problem in this situation is that we have a contrast between the formal residence, habitual residence of the deceased Tatiana, and the center of interest of her family. And so this is the so-called escape clause of Article 21, paragraph 2 of the regulation. In fact, it's true that the law applicable to the succession is the law in which the deceased had his habitual residence at the time of death. But second paragraph says that where by way of exception, so the so-called escape clause, where it's clear from all the circumstances of the case that at the time of the death, the deceased was manifestly, and this is the adverb very, very important, manifestly more closely connected with a state other than the state whose law would be applicable. So Italy, in this case, the law applicable to the succession shall be the law for that other state, in this case, Romanian law. Over to you.
Grazie per l'osservazione.
In this case, we also have to consider number 24 in the recitals on the habitual residence. For Tatiana, we also have to refer to the clearly tighter connection and manifestly closer connection. And to this refers recital 24 in the regulation with respect to the closest connection. This is what I wanted to stress on, and I believe that exactly because the habitual residence as provided in the regulation does not depend on the legal definition of the residence, the definition that each state provides. The difference is that Tatiana is in Italy, and in order to determine Tatiana's habitual residence, we have to consider several factors. All in all the circumstances of the case, and this is rather applying the escape clause. So somehow setting a priority between the contact points and determining Romania as habitual residence. Once returned to her country of origin, Tatiana has basically returned to her habitual residence. It's quite difficult to determine it, but in this case, it's quite clear that the habitual residence is...
Paragraph 2 of Article 21 can support the decision.
Sicuramente.
For the determination of the residence in Romania. In any case, because Tatiana lives alone in Italy and all her family lives outside Italy, in Romania, this may be a relevant connection factor that determines her residence in Romania.
there is a topic related to this, but prior to getting taken to another case, maybe we should speak about this a bit more in depth. Tatiana's case is a case that needs a balance between the factors referring to the Italian law. Somehow indicating to the enforcement of the Romanian law. So there are among the indicators a similar case to Tatiana's, but it rather refers to a bit more complicated case. In order to determine the habitual residence, what is the preference here, given the fact that there are several factors? Let's say you have an immovable owned in one state and you have an account in another state, although the residence is in another state. So which indicator prevails? Thank you for the question. This is one of the cases that are most complicated. And there's actually a hierarchy, or you have to set a hierarchy of the connections in this case. Only with the information that we have, and using just these details, we have to consider the following. Let's assume that the country where the individual works, there are also social relations that she has, friends, other close relations. So this might determine determine us to think that the habitual residence is in the state. Also, the person has a bank account in another state, so this account, for example, might be in state C, and we don't know how long this contractual relation has existed, but this is a case in which you can only assume. We know nothing for sure. We really do not know anything, because ownership of the immovable is again important, because the house itself is also important, and you can also take into account the location of the house in this matter. So, if I may stress the fact that these are just assumptions, these cases should constitute the foundation of a more in-depth research in trying to find out whether state A, B, or C, of course making use of the guidelines, can be determined as the main center of interest for the citizen. Using another community instruments such as habitual residence, of course, also using the principle of proximity. One solution in this respect, with only this information, is really impossible. We could just assume, as I said, and make assumptions, and we also need to get more information, as I said, in order to provide a definite ruling that I really cannot set now on. Lorenzo wanted to actually say something. Well, with respect to what Jacopo said, it's quite clear that during the sessions with these practical cases, it's quite tiresome for everybody, because it's a new piece of legislation, it's a new area, it's difficult to put in practice all the detail, because not having all the details, we are a bit of hunters that don't have very good rifles, let's say. Thank you, Carmelo and Jacopo. Now, this is quite the theoretical case. We shouldn't approach it in such a theoretical matter. The solution for the case might be found by a judge. The regulation does not provide for automatic solutions. Now, if there is a debate between the interested parties, or those that claimed a certain right as heir or legatee before the court, then they will file that application, and the applicant must provide the necessary evidence to substantiate the claim. The criterion of the applicant, used by the applicant, doesn't mean, or to use the criterion of the applicant filing the application is not the best criterion, of course, to determine on the residual, on the habitual residence. So, this might be the place where the person works. So evidence has to be provided to show that these close relations are this and this and that, and so forth. But we do not have an automatic solution provided by the regulation for these cases. If we take the perspective of Professor Juris, there's no issue. But if we don't have it, what do we do then? I also wanted to add that first and foremost, the judge has to be competent, has to have the jurisdiction, of course, because, as you said, we think from the perspective of the applicable law, using as criterion habitual residence. Habitual residence is the one in which the deceased worked. If that is the habitual residence, then that judge has to, or the judge in that area has to have competence. Maybe it's easy in this case to convince the judge that they have competence. But if we follow Article 4, it can only apply the own law. So all these situations, in fact, make us think first and foremost about jurisdiction and which competence applies, whether the courts have jurisdiction or not in the case. For us, the Spanish, these cases are quite frequent. Germans, for example, that came in Mallorca, settled in Mallorca about 15, 20 years ago, let's say. Once they retire, so the Germans buy a house at the seaside. The sons and daughters of these Germans live in Munich. So what's the criterion? All matters with respect to succession have to be applicable under Munich. The burden of proving that the closest relation of the mother and father domiciled in Mallorca, so all the evidence has to be provided by the children in Munich. A Spanish lawyer has to be determined because this is the procedure for establishing a residence and so on and so forth. the children face quite a lot of problems in this respect. Let's say that parents died on the same day to avoid complications. So for the sake of argument, what do they say? They say that the competent court is the one in Munich. If there is no opposition from the courts in Germany, then they will accept this jurisdiction.
Regulation will increase litigation about within heirs or legatees. But I can add that I think that using, for example, as Jacopo said, connecting factor as, for example, social life can lead to use discretion in determining the habitual residence. And I think that the aim of apply the unitarian principle of the law should depend on objective factors and not subjective factors. And in fact, the recital 24 give us three elements that are objective factors. In the last period of the paragraph of the recital 24, the recital said that these spatial factors that, of course, judges and notaries are going to use to determine residence could be nationality of the deceased person, the main assets. So in this situation, for example, may be relevant. The immovable that is in the state B may be a special factor because it is very important in value, and so can be a factor which prevail on the other factors. And the location of the assets could be a special factor. So I think that in the practical using of the regulation, I think that the professionals and judges will use at first these connecting factors because are more sure than other connecting factors that may lead to discretion.
Bene, grazie Daniele. Allora, era rimasta in sospeso la domanda che avevo rivolto a Lorenzo, cioè quella relativa alla difformità tra i presenti nei registri.
If I may clarify here a bit. Now, going a bit more in detail with the interpretation, maybe the most delicate question for those that have to issue the certificate would be, how do I handle a case in which the authority or the processor knows a direct case, and this contradicts the data generated by the official records. Many times the data in the public records are not updated and make us face different situations. Thank you. Well, the competent authority has first and foremost the possibility to ask for evidence in case there is doubt. If there is no other possibility to know the data 100% personally, then they have to decide based upon the evidence provided by the applicant. Secondly, when this certificate of succession was issued, the other heirs were also informed, or when making the application, the other heirs were informed. And if the heirs know that there is missing data from the certificate, then they can file for an error. So the certificate is suspended, therefore. or revoked. So should there be errors that are not quite serious, the procedure can continue and one can request for the certificate, the European Certificate of Succession to be revoked. So the judge or the notary or the competent authority has to be 100% safe, 100% safe as much as possible, or 100% sure. So this is the mission of the judge or the notary. They have to check the data. The notary has the possibility of asking for evidence. So I hereby issue the certificate, let's say, but it is very important and I have to know that all the details in order to be able to acknowledge or to recognize to an heir the right of it, because it's important to acknowledge it at the international level. I agree with what Lorenzo said, adding another detail important to me.
Taking into account that without the work of the notary, this is not possible, because the notary prepared and wrote the certificate of succession. Well, he cannot be considered responsible for that certificate, for the content of it. In the future, somebody may consider that the content of that may be wrong. What I mean is that if he confirms or certifies some data, if he or she uses their role to the maximum but are unaware of all of the elements that occur subsequently, for instance, a current account that nobody knew of, or some secret that the notary could not have known, then of course that the notary could not be considered to be responsible for the error which is materialized or contained in that certificate. On the other hand, whenever the change of the certificate is requested, there is some sort of a disclaimer that the certificate may contain some errors. So this has to be clear from the very beginning to us, the people who are doing this work. Otherwise, nobody would do this work if we were held responsible for the accurate content of this document. I dare say that, well, if there are no other questions from the audience, we could continue. We could move on with case number 3, a presentation that Mr. Muritano has prepared for us. And this case is a little bit bigger. It involves some more theoretical elements and some additional elements of difficulty.
Carlo, an Italian citizen, and is a case regarding the choice of law. Here is the situation. Carlo, Italian citizen, he has habitually resided in England, where he is domiciled in the English meaning of the word. That, you know, it's very, very different from the European meaning of residence. He works as an orchestra leader and owns movables and immovables in England and immovables in Italy. And he wishes to plan his succession choosing the English law of succession. You know that under English law we have a system of scission. That is, the law of domicile will apply to the succession of movables, and the lex residere, that is the law where the immovables are situated, will apply to the immovables. Carlo can make a choice of law under Article 21, paragraph 1, of Regulation 650. And in this case, the English law of succession will apply to the whole succession, and the English courts will have general jurisdiction on the whole succession, because Carlo is resident in England. The problem is that under English private international law, the law of the domicile, as I said before, will apply to the succession of movables and the lex rei site to the succession of immovables. Does English PIL make a renvoi to the Italian law of succession for immovables located in Italy? Italy would accept the renvoi under Article 34 of the regulation because, and this is a very, very important problem to solve, and I think that will be the European Court of Justice will solve this problem. It have to solve this problem. If the problem is if or not UK is a member state, which means a state not bound by the regulation. This conclusion, and I will come back to this issue after, is by no means straightforward according to some English professor, and I explain why. So, if we accept that UK is not a member state but a third state, we will apply Article 34, and so Italy will accept the renvoi back, and so will apply the Italian law to immovables located in Italy. The question is if Carlo, to avoid the renvoi to the Italian law of succession for the immovables located in Italy, can make a choice of law with the English law of succession. This choice of law is not allowed for Carlo by Article 22 of regulation because Carlo is Italian citizen, not British citizen, and Article 22 allows only to choose the law of nationality. And is not allowed also by the English PIL because in the Wills Act of 1963 it's void to choice of law, but the constitute of the will. The testator can choose a law only for constitute the will and not to as a law applicable that will be necessarily English law. So the question is here we have an unavoidable conflict here. But can be useful for Carlo to choose English law as law governing his succession because the choice of the English law would exclude an implied choice of law in favor of the Italian law because it's the law of the nationality. The fact that Carlo write down an English will can be construed or interpreted as an implied choice of the Italian law and not of the English law. So the choice of the English law could help to clarify a very important thing, that is Carlo's habitual residence is in England. But in this situation, common law practitioners argue that the professio juris would exclude also the application of Italian law of succession to Italian immovables. Why this conclusion? This conclusion is because it's not by no means straightforward, as I said before, that Denmark, Ireland and the UK are or not member states. This is because there is no specific definition of member state or third state in the succession regulation. And in fact, the final line of the succession regulation says this regulation shall be binding in its entirety and directly applicable on the member states in accordance with the treaties. And if the aim of the regulation had been to exclude the three states from the definition of member state, it would have been perfectly feasible to do so. But the regulation didn't do this. So the regulation don't give us not only a definition of habitual residence, but also a definition of member state or third state. May therefore be argued that even though UK is not bound by or subject to provision of the succession regulation, the definition of member state in the succession regulation does still include UK, and that therefore the definition of a third state also excludes UK. And in this topic is very dividing between scholars and between experts, between professionals, because the main point of this uncertainty relates to the application of Article 34, because if we interpret the Article 34 as encompassing that UK is a third state, so the renvoi back will apply. If we interpret the Article 34 that, as a norm that not includes UK as a third state, renvoi does not apply, will not apply, because in the same Article 34, paragraph 2, stipulates that the renvoi will not apply in case of choice of law. And so in this case, our Carlo can choose the English law as law applicable to his succession, excluding the application of the renvoi back, and so applying the English law also to the Italian immovables. This is very, very important, because if we apply to the Italian immovables the Italian law, we also apply the clawback provisions. That is the main reason for what UK didn't opt in the regulation, because they are aware about the application of clawback also for assets located in England. But in this case, of course, if the renvoi back will not apply, the succession of Carlo will be governed by English law, that will be the law applying to the whole succession, and so including also the immovables in Italy. And so Carlo can make his disposition of property under that using the English law, and so, for example, disinheriting sons and other relatives. This is a very important thing to study, because we have to decide, and I think that will be also in this case the European Court of Justice to decide what's the definition of third states and what's the definition of a member state for the purpose of the regulation. And this is the third case.
In merito al terzo caso, e quindi diciamo.
In the third case, I was saying the choice of law is applicable. The other presenters have a number of remarks, but there's also a question which we have received about the law applicable in this particular case. But I would like to check with the audience to see if there is anything to note here. If not, we should try to answer to the question. We want to have an answer to this question, starting possibly from Ioana. So the question is, if there is anybody having its habitual residence chooses as applicable law the law of a state different from the country of citizenship, and the question is if the law is really applicable and if the habitual residence is transferred to a different state, or if the transfer of the regular habitual place involves the enforcement of a different law.
Different problems in the question. First of all, if we take into account the provisions of the regulation, when a person changes his residence into another country, and he had already made a choice of law, the change of the residence doesn't affect the choice he already made. But because the question has so many unknown points, like is the country C a member state or a third state? Is the last residence of that person in country C? Is there are any indications that the authorities of country C will stay to regarding this succession? And does the country C, which have become competent, accept the choice of law? There are many questions and many points that are not in the question, but if country A, B, and C are all member states and the choice of law has already been made, I think, and the regulation speaks for itself, that the change of residence cannot affect the choice that has been made. Also, we have to take into consideration that the declaration regarding the choice of law is a different act that only is concluded in a form of a will. So, if the consequences or the hypothesis of automatically revocation, it's a legal revocation, are due to the specific elements like selling the immovable, the choice of law will, and the will is a particular will, the choice of law will still remain in place, and only the will or the deed of transferring the property to the inheritors will be revoked. In some states, concluding another marriage is a case of legal revocation of the will. And of course, if this occurs, I suppose under the already chosen law, yes, it will be difficult to state if the choice is still producing effects or not. But the mere changing of the habitual residence from one country and another cannot affect the law that has been already chosen.
Grazie molte.
Can I add? That the notarial counseling in made a will is very important, and the main thing we have to say to our clients is to update eventually their wills. Also because the question, we can enrich this question supposing, for example, that the person buy a home in the state C, and the problem is if the state C is a member state or a third state and accept as law applicable to the succession the law or the nationality of the or the law of, for example, maybe the lex resite, and so the problem of renvoi came out again, and so all the problems I spoke before came out in deep.
Quello che osserva Daniele mi sembra molto importante, aggiungerei.
These are practical issues. These are practical issues. I am unable to hear the feed sound, so we need to check for this technical problem. We need to wait for the technical problem to be solved. I apologize for any inconvenience. I apologize for any inconvenience on behalf of the technical team. We need to wait for the problem to be solved. I don't hear the speakers. But Jacopo has a number of clarifications about the third state, about the country C. Well, problema este
in third
că
states,
imobilele din statele...
we always have to keep in mind that Article 12 of the regulation may be a mean in order to avoid that the succession will cover immovable or goods in third states. If a party asks so a limitation of stay, a party asks so, and there are good reasons that the judgment will not be recognized and enforceable in the third state. So always when we talk about third state, we always have to consider even this rule, Article 12 of the regulation, and the limitation of stay.
Allora, mi fanno segno.
Therefore, as far as I understand, we can continue. The problem with the translation has been solved. We should now move on to the discussion on the case number 4, and then we will take more questions.
Case number
Daniele,
4
please.
is Molly case. Is a case regarding two topics of the regulation. First one is the formal validity of disposition for property upon death, made in writing, and the other one that we see in the next slides is the validity of the revocation of disposition of property upon death. I present this case distinguishing before and after the 17th of August 2015, because the case, it is a real case, happened. Is a case in which Molly died in 2013. Molly is an American citizen, and she lived in South Dakota until 1970. Then, from 1970, she never went back to the USA except for some visits to her parents until their death, and she lived in Scotland. So she moved from South Dakota, from United States, in Scotland with her husband, who was a British citizen, and she lived in Scotland for 10 years, since 1970 to 1980. And after 1980, she moved in Italy. So since 1981 until her death, and she died in 2013, she lived in Italy. And Molly was recorded as resident in Italy since 1986. This is the first facts. Molly owns immovables and a bank account in Italy and just movables in Scotland. Molly and her husband had a child. This child is resident in England, and Molly died in Italy in 2013. This is a succession governed by a will, by two wills, and we have to decide which of these two will govern the succession, the Molly's succession. The first will was made in 1996 in Scotland, according to the formal requirements of Scottish law. One witness, namely the requirements of writing Scotland Act 1995, which came into force on 1st of August 1995. Then Molly made another will, a second will in 2012 in Italy. This will is under the formal requirements, again, of Scottish law, and by which she revoked the first will, the previous will made in 1996. And the sole heir of Molly was her husband. All her estate was bequeathed to her husband. So what happened to the law applicable? What is the law applicable to Molly's succession before 17th of August 2015. According to Article 46 of Italian PIL, the law applicable is the law of nationality, and Molly is an American citizen. So we will apply the South Dakota law of succession. South Dakota use a system of scission, as most of common law countries. So we will apply the law of domicile to the movables and the lex reisite to the immovables. So the question is to identify where is Molly's domicile. Domicile in the meaning of common law domicile, because if the domicile in the common law meaning is, for example, outside Italy, the law of this domicile will apply to the movables. So in this situation it is quite clear that Molly has no domicile in South Dakota, because the sole connection is Molly's nationality, because Molly left South Dakota in 1970. No domicile in Scotland, because Molly left Scotland in 1980. The domicile is in Italy, of course, because Molly lives in Italy since 1981. So, applying the Italian PIL, and so the Italian law of succession, we will apply also Italian law to the movables. Why? Because the law of the nationality, so the law of South Dakota, makes a renvoi back to the Italian PIL, according to Article 13 of the Italian PIL, a renvoi back to the Italian law of succession. So we will apply to the movables and to the immovables the Italian law of succession. So the whole succession of Molly will be governed by Italian law. This is the situation before the regulation. Slightly different is the situation after 17 of August 2015. We have to distinguish the law applicable to the succession and the law applicable to the formal validity of the wills and the revocation of the will made from the second will, as I said before. Here the relevant is Article 21, as you know, according to the regulation. The law applicable to the whole succession will be the Italian law of succession, because Molly is a resident in Italy. Her habitual residence is in Italy. According to the Scottish PIL, no problem, no difference, because the Scottish PIL, if we look at the will made in 1996, made in Scotland, there is a renvoi back, because all movables and all immovables are located in Italy. So there is no problem of conflict of law rules for the succession of Molly. So all her assets are located in Italy. Her habitual residence is in Italy, with no problem of renvoi. The problem rise about the formal validity and the revocation of wills. Because the 1996 will is certainly valid because drafted in compliance with the Scottish law. The will was made in Scotland. Instead, the second will, the will made in 2012, according to Article 48 of Italian PIL, is invalid because it doesn't comply with the formal requirements of Italian law, neither when the will was made, 2012, nor when Molly died. And it also doesn't comply with the formal requirements of South Dakota law of the nationality. Because, as you know, in the regulation, we have lots of law applicable to the formal validity of regulation, and in the regulation, Article 27 manifestly is an article that whose aim is to give us a favor testamenti. So it's sufficient that to have a formal validity that the testament will respect just one of the laws indicated in this article. The same 2012 will is invalid according to Scottish and English law, because the Wills Act 1963 reproduced the Hague Convention of 5 October 1989, not ratified by Italy but ratified by UK, and it would not be valid, neither according to Washington Convention of 1973 about international wills, which bounds Italy, the USA, and UK. I can't go deeply in the formal requirements because I have time to do this. But trust me, it's invalid. And here is the other question. Is the revocation of the first will valid? Remember that the second will revoke expressly the first will, and Molly bequeathed all her assets to her husband. In the Italian PIL, we have no disposition about formal validity of revocation, even if Article 48, according to some scholars, is applicable in the sense of analogical or extended application not only to the formal validity of the will, but also to the formal validity of the revocation of the wills. But in this case, because the revocation is contained in an invalid will, the revocation itself is invalid as well. Consequently, the will which regulated the succession will be the 1996 will. This is very important. But after the regulation, the problem, I think, would be solved, because the Article 27 stipulates that the modification or revocation shall also be valid as regards the form if it complies with any one of the laws according to the terms of which, under paragraph 1, the disposition of property upon that which has been modified or revoked was valid. And the Article 27 reproduces the Article 2 of Hague Convention 1961 on the conflicts of law relating to the form of testamentary disposition. In fact, the revocation of the first will would be valid as it complies. The wording is similar with the law according to the terms of which the testamentary disposition that has been revoked was valid. So, in this case, after, if Molly had died after the 17th of August 2015, in my opinion, the revocation of the first will made with the second will would be valid, because we could apply Article 27 that, as I said before, make a favor testamenti, and so provide that the revocation is valid according just to one of the laws that are indicated in the article itself. This is the solution I propose. I finished my presentation. Thank you for your attention. And if you have any question, don't hesitate to ask us. Thank you.
Allora, per prima cosa.
Now, let's see, first of all, and assess whether there are questions on the last case submitted that for sure is complex, to say the least, for a series of reasons, of course. Especially for the necessary review on the relations between the laws, so regulation and other international regulations. Are there any questions with respect to the last case? If so, I would start with these questions and then I would switch to looking into other 2 or 3 questions that have been asked online. Please.
I would have one question. Aș avea o întrebare, nu e?
I have one question. It doesn't relate to the last case. It relates to Tatiana. So, in practice, the notaries are informed with respect to a succession according to the regulation, and the habitual residence has, in this case, is of a complex nature. Can we, as notaries, determine that the residence of an individual is not where indicated in the documents, but in another state where the center of interest of the person is? Or you need an investigation carried out by the court? So could the notaries determine that the habitual residence is in another state than what the documents attest? And if we can, what documents do you think should be submitted to us, the notaries, to be able to make this assessment? Thank you.
Penso di essere principalmente.
I am mostly interested, let's say, to answer. So, for sure, it is possible. Let's say that the habitual residence is in another state than the recorded residence of the person according to the documents. So this is possible because the habitual residence is an autonomous term. It's a de facto criterion that pertains to each case. For Tatiana, for example, this is the residence on her, recorded on her documents as well in Italy. For all the other circumstances, it is our understanding that, as opposed to this recorded residence, the habitual residence is Romania. I believe I didn't understand or didn't hear the first part. It was about what evidence must be provided to make the review. Let's see if Laurencio can help me. So in the form, in the European Certificate of Succession, there is a provision on the applicable law. It's one of the points on the form. So based on which article was that law as applicable? And based on which documents or deeds was the Romanian law considered applicable? Because Tatiana had the habitual residence in Romania. Well, in that part of the certificate, one can write all motivation leading to the choice of law. On the other hand, the habitual residence is Romania because her home, her family, her bank account are there, based on which a close relation is shown with the family. So with the bank account where she transferred some of her monthly salary. And all these make us conclude that the habitual residence is Romania. On the certificate, there's all the necessary space for all these explanations. I don't know whether Lorenzo wants to add to this answer. The matter of determining the applicable law is that the competent authority, the competent authority to solve the conflict, is it the judge or is it a notary? The notary can decide this, but it might be sufficient that for another person that believes themselves to be entitled according to the applicable law, to raise doubt, so as then to take this action to court and to determine the applicable law. So we go back to the initial problem. If we apply Article 4 and the following, the competent court, for our case, will be the court, or the competent authority will be the court of the member state where the person had their habitual residence upon death. If, or unless the person made the choice of law applicable according to the state that they chose. So this applies only if the person didn't make the choice already. So if the person didn't make the choice, then the court is competent to decide on the applicable law. The limitations of the competences or the jurisdiction with respect to notaries apply when there are discussions on applicable law. Another thing can be said here. When the European Certificate of Succession is requested and issued, the competent authority can issue said authority from the states indicated in Article 4, 7, and 11 in case of determining jurisdiction. So for Tatiana, the Romanian notary can issue the certificate because they are the competent body according to Article 4. And not just the applicable law will prove this, but the jurisdiction will also be, or the competent authority will also be determined. As mentioned in the morning, once the European Certificate of Succession is adopted, then the judge must have access to the details. If taken to court, the Romanian judge will assess whether, in order to determine the habitual residence in Romania, there are sufficient arguments in this respect. And for sure, the judge will in this case approve or stand by the decision that the notary took.
In point 6.10, and that is blank space. Any other information which you deem useful for the purposes of the issue of the certificate, in addition to the information in section 4 of the application form or the annexes. And another important thing is that in the clause dealing with the documents attached to the application form says that the applicant shall provide all relevant documents to prove the information contained in this form. This is very important. So the first thing that the notary or the judge must do is to examine the documents that are the proof, because the burden of the proof or the onus of the proof, as Lorenzo said, is on the applicant, of course.
One of the matters does not regard the applicable law, but the change in time of the indicators used to determine habitual residence. The question is, can the applicable law change as a result of a decision or of another interested party? Let's say you have person A transferred in state B with employment contracts in state B, wiring money into the accounts in state D. The person doesn't change their location, but their professional activity is different. Question is whether this can lead to a change in the habitual residence that was already determined. Thank you for the question. If I understood correctly, what changes? The law regulating the labor contract, the location of the employment is changed? No. The person? No. So I don't think that this constitutes as a major change. Just the bank account is transferred. Or better say, the workers are asked to open a bank account in state B, where the company relocated. And apparently this is the only change that is relevant. Frankly, I believe that yes, there is a new cross-border detail. This new detail is not sufficient. Is not a sufficient change without knowing all the other details. So I don't think this intervenes in changing the habitual residence of this person. The fact that they opened a bank account in another state does not have a decisive influence. Yes, I agree with your answer because I think it's too far-fetched to hypothesize on a situation that would lead to such a change. So
ecco, invece venendo al caso
habitual residence. Coming back to the case in which the choice of applicable law was already made, the question asked online relates to a change in choice. So a citizen in state A that chooses the applicable of this state A, state of nationality, but later on the person becomes a citizen of another state consequent to marriage. Question is whether the choice of the applicable law made prior to the marriage continues to apply when the nationality of the person changes as a result of the marriage. To answer here, I would start from Ioana.
Of course, the change of the citizenship will have no effect regarding to the previous choice of law. If the person had the citizenship of the country A at the moment he had made the choice will still remain valid even if the person is no longer the citizen of country A at the moment of death. So if he acquires another nationality, the only effect will be that he will be able to make another choice and make the applicable law the law of the state B of the other citizenship he had acquired.
Questo
when we advise our clients that ask about having a certain guarantee that their estate will be under the applicable law of their nationality, well, we can answer by being a bit forward. So whether the possibility of the change in citizenship is real, and whether it might affect the determination of the habitual residence, but it also depends on how the person expresses their written statement. If the citizen at that time is Italian, let's say, one way of expressing this choice would be that the document stipulate that the law, or that the citizen wants that the law be the national law, and you might understand that this national law might be the Italian law, not the Romanian law.
In fact, to clarify to the testator, that it is important to write in the will what is the reference time of the choosing of law. Is the time of the citizenship he has at the moment of the choose, or at the moment of the test. It is very important. Otherwise, there can be uncertainty about the law applicable to the succession. So again, the counseling of notaries will be important, of course.
Ci sono osservazioni o domande su?
This morning, from the discussions, actually from Dario Restuccia's presentation, I wanted to bring to your attention some items. Now, if you don't have other questions, I would like to refer to this reference of Dario from the morning. So, this morning I heard Dario saying this, and Jacopo actually made a comment on the possibility to, for the application of the regulation to lead to a reverse discrimination. A reverse discrimination which can affect a citizen in a certain state. The matter that we raised is addressed to Lorenzo or Jacopo as well on their object of activity. So, question whether the applicable law can serve the purpose of regulating or having a competent authority the person that is not a citizen of that state of the competent authority. Coming from Italy, I rely on the succession agreement, which in the Italian legislation is not allowed, but this is allowed in another legislation. This is just one example, a major example of a possible use of the regulation in order to expand or to increase the ranges of possibilities from the countries. Maybe others can jump in. But of course the same is applicable to Spain as well. Catalonian law, where the succession agreement is approved, but in the general law this is not approved. But coming back to the matter at hand, the regulation has a general principle according to which there is an autonomy of will, of expressing one's will. And this expression of one's will would be that the citizen chooses the legislation applicable to their succession. So their freedom of choice is not hindered. Were this to be hindered, it would contradict the law and the interest of third parties. There are situations in which one's choices could be revoked or annulled. So in this case, professio juris is applicable. If I choose the applicable law for a succession, this is an expression of one's will, and therefore my right as a citizen for autonomy and freedom must be observed. We cannot fraud the law, we can only fraud third parties, because third parties can file a claim against this choice. Yes, thank you for this matter as well, that I believe to be very, very interesting, because it presents a new content to the choice or to the will of a citizen. Let's take the example of a person with both Italian and German nationality. They want, or citizenship, they want to set up a succession agreement. They can do this at will, according to Article 25, first paragraph, referring to an early succession. Since they are, so the person is a German citizen, the German legislation allows for all the conditions for the validity of the law. So they make the choice. There's no problem. The succession is carried out according to a choice. However, let's take another situation. A succession agreement referring to the succession of two people, one Italian and one German. Article 25, second paragraph, says that for a succession agreement to be valid on the succession of several individuals, this has to be admissible according to all the applicable laws at the time. So for each applicable law, as I said, for the Italian person, if they agree on succession with a German citizen, according to Article 25(2), then both the Italian and the German law have to allow for admissibility. But there's also 25(3) that says that anything with respect to the succession agreement for several parties allows for the choice of the applicable law, because there can be several or different choices. Let's say that the German can choose the law, but the admissibility condition of the succession agreement would regard the possibility according to the applicable law, but the Italian with the residence in Italy can conclude a succession agreement regarding both their succession with a German citizen domiciled in Italy. So the question is there discrimination in this case of the Italian that wants but cannot conclude a succession agreement with another Italian in Italy, with all their assets in Italy? It makes sense as far as the law goes. So it could be a discrimination, but not legally speaking, because it's a purely internal situation of the state, whereas the agreement between the Italian and a German, this is a cross-border and a different approach. So it's not accurate to treat the two the same. The European Court of Justice always mentioned the principle of legitimacy. It's not discrimination. It were discrimination had this been two identical situations, but the situations are yet different. In this case, from a legal perspective, the situations are different, and specifically because they are items of internationality, the international private law is applied. So it's not a specific case of these guidelines in this situation. This requires a regulation that should not be really confined to a legal system, because it might affect the obligations stemming from the succession agreement. But it might also be an incentive for the legislator that tries not to affect this succession agreement. The Italian notaries know this very well. So, legally speaking, this is not a discrimination. Thank you. If I understood the rationale correctly, we, at least in this case of this version of the guideline, we should conclude that the succession of an Italian citizen or of a country that does not allow for succession agreements, as long as it's not transnational, cannot be regulated only by the legislation in their country without leading to discrimination, as opposed to the case in which there is the transnationality or the internationality perspective. This was a matter of discrimination that we tackled the morning as well. Well, it's true what you say, Jacopo, on international discrimination as far as the private law goes. The Court of Justice when ruling on Stin 2 said we deal with these situations. We don't deal with the effects that the regulations have at the national level. This concerns the judges in that particular state. What I do refer to is the judgments in Italy passed by the Constitutional Court, because Italian judges have to tackle this based on the principle of legitimacy and equality and have to clarify this. Actually, this is what all community law states starting 2010. I know that there's also case law in France, to my knowledge, with this respect. And I believe that there is, however, discrimination, legally speaking. Why? Because the cross-border element, or the transnational element, is not decisive in order to rule on the legal situations. For example, let's say that you have a bank account abroad. This cannot result into a different treatment. This is very little. It is very little, but it is not a criterion that allows me to do this. It's quite true, but in my opinion, we have to look at things differently. Why should the succession agreement be treated differently, as opposed to the possibility of issuing the certificate? Because why is it enough in that case? If there's a bank account in Germany, I cannot conclude an agreement, a succession agreement, but I can ask for a European certificate of succession that I can use in Italy. So why can't I use this? Is it relevant with respect to the evidence? In France, in Italy, in Spain, it's the regulation of these practices is quite incredible. If you have to say that, well, according to the Italian laws, you have to prove that you're the heir, and others, according to other regulations or states, don't have to prove. So for me, the actual existence of a bank account in another country is not a sufficient criterion for this. And you can't really neglect or ignore the restrictive obligations in this case with respect to the agreement, succession agreement. They might be in Romania and in Spain as well. These do not constitute as the condition for this. Thank you, Dario. Well, if there are no other questions or comments from the public or from the people that hear us on and follow us online, we could reach the conclusions of the day. My very brief conclusions to wrap up these two sessions would be that we cannot conclude, really. We face a instrument, a piece of law that is new, that can leave room for several interpretations. We have a very clear, different cases, practical cases, different not just from one legal system to another, but within the same legal system as well. So it is impossible, as Lorenzo said, to try to find universal or uniform solutions. For us, used with this type of situations, maybe this is the most fascinating challenge that this subject matter raises. And we have to understand that this generates also the possibility of a requalification of our role, of our profession in relations with the citizens, with family advisory services, with successions, but with the choices that each of us might make with respect to their investments. And of course, if I were to concern myself with what will follow when I'm gone, then I should also adjust my life for a couple of tens of years longer. So if I am well advised at the beginning, and if I am always informed on this, then it would be very useful for me. And I'm also trying to cover now the defaults.
The problem with the regulation is that it takes some of the space of the codings that we already know, because there were some codings that we knew, and taking some of these codings away could create some problems, but there are pretty numerous anyway, and this is anyway a fascinating, challenging. Thank you very much. I would like to thank to the organizers, to the presenters, to everyone, and I like to wish all of you a pleasant evening, and I wish to see you sometime in the future in another event like this. Thank you very much.